She didn't even look at me when the judge asked if both parties were ready. She was whispering something to her attorney, a guy in a charcoal suit who charged $450 an hour and had his name on a billboard on I-95. And she was smiling, not a nervous smile, not a polite in court smile. The kind of smile that meant she'd already decided how this ended. I was sitting alone at the other table. No attorney. A manila folder, a USB drive, and a legal pad with notes I'd written by hand at my kitchen table the night before. The judge looked over at me. Mr. Harlow, are you prepared to proceed without counsel? Yes, Your Honor. My ex-wife. I'll call her my wife here, because at that point we were still technically married. Turned just far enough to catch my eye. And then she laughed. Not loud. Just a small, quiet exhale through her nose. But she couldn't help herself. Her attorney touched her arm. She straightened up. But I saw it, and I thought, good. Let her think that. I need to back up about 3 years, because none of what happened in that courtroom makes sense without understanding what the years before it looked like. I was 28 when I married her. I know how that sounds now. I was 28, I was working 60-hour weeks as a project coordinator for a mid-sized construction firm, and I thought I had found someone who understood what it meant to build something from nothing. She came from money. Not old money, not the quiet kind. The kind that gets loud at family dinners. The kind where her father spent the first 2 years we dated, reminding me, in different ways, that I wasn't quite the right fit. He never said it directly. He'd ask about my trajectory. He'd mention her previous boyfriend, a guy who'd gone to Duke and was now at some hedge fund, in completely unrelated conversations. She never defended me. I told myself that was fine. That she showed me in other ways. We got married in the fall. Small ceremony. Her parents paid for most of it, which I learned later came with terms I hadn't been told about. By year 2 of the marriage, she'd convinced me to leave my job and come work for her family's company. Her family owned a regional freight logistics business. Not glamorous, but it did about $18 million in annual revenue. Her father was technically still the CEO, but had mostly stepped back. She ran operations. I was brought in to manage the technology infrastructure side, new fleet tracking systems, vendor contracts, driver scheduling software. I was good at it. Within 18 months, I'd renegotiated 3 vendor contracts and saved the company close to $400,000 annually. I built a driver retention program that reduced turnover by 31%. I wasn't the flashiest person in any room, but I did the work, and I had the receipts to prove it. Her father warmed up slightly. Slightly. Then things started to change. She started treating the business like it was hers alone, which, legally, it mostly was. Her family held the majority of shares. But the way she ran meetings, the way she talked over the other department heads, the way she started making decisions without looping anyone in, it shifted something in the culture of the place. People started leaving. People who'd been there for 10, 12 years. At home, it was quieter but not better. She worked late. I worked late. We stopped talking about things that mattered. When I raised concerns about the direction she was taking with a few of the vendor relationships, some of which I'd personally built, she told me I was being territorial. I wasn't territorial. I was reading the financials. Something wasn't adding up. The company had a separate discretionary budget, about $2 million that flowed through a consulting subsidiary her father had set up years ago for operational flexibility. It was supposed to cover things like contract labor, third-party audits, specialized equipment, legitimate stuff. But when I started looking more carefully at the invoices run through that account, I found vendors I didn't recognize. Companies that, when I searched them, had no web presence, no address, no record of ever doing work for us. Ghost invoices. I didn't say anything at first. I didn't want to be wrong. I didn't want to blow up my marriage over something I'd misread. So I started keeping records quietly. I didn't take documents. I didn't need to. I had system access as part of my job. Every time I found something that didn't track, I screenshotted it, logged it with a timestamp, and saved it to a personal encrypted drive I kept at home. I did this for 4 months. By the time I stopped counting, I documented just over $900,000 in payments to entities that did not exist. That money went somewhere. It didn't go to the company. I confronted her. I laid it all out at the kitchen table on a Sunday morning. I had printed pages, I had the spreadsheet, I had dates. I wasn't angry, I was deliberate. I said, I need you to explain this to me because I don't want to believe what this looks like. She looked at the papers. She looked at me, and she said, "You're going to want to be very careful here. Not a denial, not an explanation, a warning." I sat with that for 3 days. Then I called a divorce attorney. The attorney I spoke to was good, highly recommended, straight talking, 40 years of experience. She reviewed what I had. She said my documentation was unusually thorough for someone without a legal background. She said I had a strong case. She also said her retainer was $40,000 to start. I didn't have $40,000 sitting anywhere. The house was in my wife's name. My salary from the company had been rerouted, I found that out later, to an account she controlled. I had my personal savings, which covered my basic expenses for about 4 months and nothing more. I told the attorney I couldn't make that work. She gave me the name of a legal aid resource and told me that in certain civil cases, a well-prepared pro se litigant could be competitive. She said it in a way that wasn't dismissive. She was being honest. I spent the next 6 weeks preparing like it was the most important project I'd ever managed in my life. Because it was. I read every pro se guide I could find. I watched hours of courtroom procedure videos. I reached out through a retired civil litigation paralegal who'd posted resources online and who, when I explained my situation, agreed to do 2 informal review sessions with me for a flat fee I could actually manage. She walked me through how to structure an argument, how to introduce evidence, how to conduct a cross-examination without getting emotional. She told me the #1 mistake pro se litigants make is getting personal on the stand. She said the courtroom rewards precision, not passion. I wrote that down. I repeated it to myself every morning. I also filed a separate report with the state's business fraud division. Quietly, before the divorce proceedings formally began, I didn't tell my wife I'd done this. I didn't tell anyone. I just made sure it was in motion. The first day in court, her attorney, I'll call him counsel, spent 45 minutes presenting their version of the marital estate. The picture they painted was of a woman who had built a family business, brought her husband in out of generosity, and was now dealing with a disgruntled spouse making unfounded accusations to leverage a better settlement. I sat and listened, and I took notes. When it was my turn, I stood up. I straightened my jacket. A blazer I'd bought specifically for this. Nothing expensive, but clean. I addressed the judge directly. I laid out, in plain terms, what I was there to prove, that marital assets had been systematically diverted, that documentation existed to support this, and that I intended to present it. The judge, a woman in her 60s who'd seen enough of these to not be impressed by much, looked at me for a moment. "You understand you're proceeding without representation?" "I do, Your Honor. Proceed." I introduced my first exhibit, 12 months of bank statements from the consulting subsidiary, cross-referenced against the company's internal expense logs. I had everything tabulated. I had it organized by date, by vendor, by amount. Counsel objected 3 times in the first 10 minutes. Each time I addressed the objection, cited the procedural basis for my evidence, and moved on. By the 4th objection, the judge said, "Counselor, let him finish." My wife, at that point, had stopped looking at me. She was looking at the table in front of her. I called her to cross-examination on the 2nd day. This was the part I'd rehearsed the most. I had every question written out in sequence. I knew where I was going before I started. The retired paralegal had told me, "Don't ask anything you don't already know the answer to. Don't ask open-ended questions. Lead." I asked her about the consulting subsidiary. She said it was a standard operational account. I asked her to identify vendor reference 7 on the exhibit, a company called Clearfield Advisory Solutions that had been paid $62,000 over 8 months. She said she'd have to review her records. I said the records were already in evidence and asked her to look at page 4. She looked at page 4. I asked if she could confirm that Clearfield Advisory Solutions had no registered business address and had been incorporated 11 days before its first invoice to the company. Counsel objected. Relevance. I explained that the pattern of shell company invoicing over a 12-month period represented a systematic diversion of marital assets, which was directly relevant to equitable distribution under state law. The judge overruled the objection. My wife answered that she wasn't familiar with the specifics of how that vendor was onboarded. I asked who was responsible for vendor onboarding approvals. She said, operations. I asked who ran operations. She didn't answer immediately. I waited. The room was very quiet. I oversee operations, she said. I moved to the next exhibit. By the afternoon session of the second day, counsel requested a brief recess. I don't know what was said in that hallway. When they came back, the energy had shifted. Counsel was more measured. My wife had stopped whispering to him. On the third day, I presented the final exhibit, a summary report compiled from the fraud division inquiry I had filed months earlier. It wasn't a full investigation outcome. Those take time. But the division had formally opened the case and issued a preliminary acknowledgement letter that I had requested in writing. It confirmed that the transactions I had flagged were under active review. Counsel went still when I introduced it. The judge reviewed it. She asked how long the inquiry had been in progress. I told her 4 months. She made a note. I want to be clear about something. I wasn't doing this to destroy my wife. I want to say that and mean it. I had loved her. At one point in the way you love someone when you're still figuring out who you are and you think the person in front of you has answers. I had built things with her. I had worked for her family, tried to earn the respect of a man who decided before I walked in the door that I wasn't worthy of it. But the money that went through those shell accounts, some of it had come from operational cuts. Fuel budget reductions, maintenance deferrals on vehicles that drivers depended on to be safe on the road. 3 drivers had flagged maintenance issues in the 12 months those invoices ran. One of them had filed a formal complaint that had been quietly closed without action. That mattered to me. More than the money. The judge issued her ruling 6 weeks after the final hearing. Equitable distribution in my favor. The full value of my documented contributions to the company over the marriage, calculated at market rate for comparable roles, plus a percentage of marital assets proportional to what had been diverted during the period I documented. My wife was ordered to pay. The amounts were significant. More significantly, the divorce judgment was forwarded to the fraud division as supplemental documentation for their ongoing inquiry. 14 months later. I wasn't in the courtroom for this part, but I was notified. She entered a plea agreement on 2 counts of financial fraud. The terms included repayment, a substantial fine, and 18 months of supervised probation. The family business was restructured under a court-appointed administrator during the inquiry period. Her father called me once after the plea. I didn't answer. I don't feel good about that, and I don't feel bad about it either. I feel like a person who did what he had to do and came out the other side, still knowing who he was. That's the part nobody tells you about going through something like this. The goal isn't to win. The goal is to not lose yourself in it. To not become someone you don't recognize. To stay calm enough, precise enough, grounded enough that when it's over, and it does end, eventually, you can look at what you did and stand behind it. I represented myself in a divorce proceeding against an attorney who billed more per hour than I made in a day. I didn't win because I was smarter. I didn't win because I was lucky. I won because I spent 4 months paying attention when everyone around me assumed I wasn't. She laughed when I stood up at that table, a small laugh. The kind people make when they've already decided they know how something ends. The thing about quiet preparation is that it doesn't announce itself. It just shows up. On a USB drive. In a manila folder. In a question you already know the answer to. And when it does, the people who laugh stop laughing. Not with drama, not with a speech, not with anything worth a highlight reel. They just go quiet and you move on to the next page of your notes, and the room does the rest. I've thought a lot about what actually happened in that courtroom. Not the legal part, the human part. The moment counsel stopped objecting so aggressively. The moment my wife stopped whispering and started staring at the table, the moment the judge made that small note in her file and the air in the room changed. None of that happened because I was brilliant. I want to be honest about that. I made mistakes during those proceedings. I stumbled over procedural language on the first morning. I had one exhibit partially mislabeled and had to correct it in front of everyone. I was nervous in a way I hadn't expected. Not shaking, but hollow. The way you feel when something matters so much that your body doesn't quite know what to do with it. What I had was preparation. 4 months of it, quiet, unglamorous, no one watching preparation. The kind where you sit alone at a kitchen table at 11 at night and read case procedure documents because there's no one else who's going to do it for you. And I've come to believe that preparation is its own form of character, not the flashy kind. Not confidence or charisma or the ability to walk into a room and command it. I mean the kind of character that shows up in what you do when no one is watching. when the outcome isn't certain, when the person across from you has every structural advantage and you have a manila folder and a USB drive and notes you wrote by hand. What my wife did. The shell invoices, the ghost vendors, the diverted funds. That wasn't just dishonesty about money. It was a choice, made repeatedly over months, to treat the people around her as instruments rather than people. The drivers who filed maintenance complaints. The department heads who got pushed out. Me. Every one of those decisions compounded. And when the full picture was laid out on a courtroom table, it didn't require dramatic speech or a breakdown moment. It just required someone willing to look at it clearly. That's the part I keep returning to. Consequences aren't dramatic most of the time. They're quiet. They accumulate the same weight choices do, one at a time, unremarkable in isolation, until suddenly the weight of all of them is sitting in a manila folder that a judge is reading in silence. I'm not the person I was before this happened. I don't mean that in a grand way. I mean, I understand now that being underestimated is only a disadvantage if you believe the person doing the underestimating. My wife's attorney looked at me that first day and saw someone without resources. He wasn't wrong about the resources. He was wrong about what I'd done with the time I had. Intelligence isn't a fixed thing you're born with. It's mostly just attention, paying it, sustaining it, applying it to the thing in front of you, even when that thing is difficult and unglamorous. And no one is going to congratulate you for the effort. That's what got me through those 6 weeks of preparation. That's what got me through 3 days in a courtroom. If you're in something hard right now, something where the other side has more money, more access, more of whatever the world uses to measure power, I'm not going to tell you it's easy. It isn't. But I will tell you that the gap between where I started and where I ended wasn't closed by luck or talent. It was closed by showing up every single day to the work and refusing to walk in there as anything less than fully prepared. That's all I had. It turned out to be enough.